Yes, Mr. Bartley.
My Lords, before the luncheon adjournment, I opened...
Can I just say the court cannot sit beyond 4:20 today?
So the principles relating to relief and forfeiture are known, and the judge correctly adopted the observations in Wittenheim, which I've reproduced in my skeleton argument at paragraph 44, and which relates specifically, happens to relate to a charter party. The point that I made, which I maintain, is that the judge's approach to this issue was flawed because he had to consider two quite separate considerations. One was the equity itself.
Was this the point you made this morning?
Yes.
Well, you don't need to make that again.
Yes.
You need to show us why he didn't do it.
Yeah. So I can show you how. And I did say this morning that it's supported by the authorities in particular. I say it's Freifeld and also the RBS and Highland case. Both seek to
speak up a little.
Yeah, both in Freifeld.
Oh yes.
And in the RBS and Highland case, both of those concerned unclean hands being used and the question of the equities, and the issue concerning the equities is a separate question from unclean hands, and that I say is identified in both the RBS case and in Freifeld.
Can I just understand the punchline? Do you say, suppose the judge has decided and had a basis for deciding that there were here unclean hands in the matter connected with the equity. Is your point that he then had to weigh that against other matters?
Yes. And
you say that's apparent from the RBS case and Freifeld. Which are the key paragraphs?
Yes. So if I start with RBS, and I just so if I'm going to take as a reference point, first of all, paragraph 8, which talks about relief and forfeiture being being discretionary, therefore the conduct of the lessee is relevant. The discretion is wide.
Sorry, what are we looking at?
I'm looking now in the authorities bundle.
Yes.
At the case of the case.
Which tab?
It's tab.
Tab 9. Yep. Which paragraph?
It's actually tab 6 in mine.
Oh well, there you are.
RBS and Highland.
I thought you said Freifeld.
No, I'm going to Highland first, if I may.
I see. Okay. Yes. Which paragraph?
First in time. So
this case isn't reported anywhere, surprisingly. Is that right?
No, this is an appeal from Justice
Don't worry about that. I just wondered, is it reported anywhere? We've only got an unreported version.
Yes, I've noted that. I don't know whether it was available in any other form.
Well, perhaps someone can check, but not spend time on it
Yes.
now, because if we're going to refer to it in our judgment, we'll need it in the reported
Yes.
version.
Yes.
Yes, paragraph.
So, first, very simple, the context was that Mr. Justice Burton refused to grant RBS an anti-suit injunction to prevent proceedings in breach of a jurisdiction clause. And he specifically deals with, in paragraph 88.
Right. First Amendment. We read paragraph 88 to ourselves.
You can do paragraph 88 to 89 and 89.
Very well.
Yes, so that's simply saying what the judge did. Where's what the Court of Appeal says?
Yes, if paragraph 160, paragraph 163 is, well, begins at 158. But I think what...
Very well, just one moment.
And I particularly want to draw attention to 163.
We'll skim read the surrounding
Yes,
paragraphs and read once it's fully. Very well.
Yes, and in 163, the point that I've just is the two elements, to identify carefully the two elements, the equity sued for and the misconduct.
But he doesn't, the court isn't there saying that there has to be any balancing.
But they are two separate, what they're saying is that there should be two, that there are two separate, that there are two elements.
Well, you have to look at whether the unclean hands are sufficiently connected to the equity you're seeking.
You do.
But that doesn't mean you balance the thing.
Well, in this case, the appeal was dismissed. They upheld the judge that denied the relief. But the point of principle that I'm taking from this is that it is necessary to differentiate.
Yes, but you've made that point already.
Conduct.
What about my Lord's point?
The issue of balancing, I think, is better expressed in the Freifeld case. If I could take you all to that.
Which paragraphs?
So if one wants to have Freifeld, I just want to draw attention to paragraph 8, which talks about the width of the discretion, not subject to rigid rules.
Yes.
The judge there found serious misconduct on the part of the lessee, that he had deliberately alienated. That was the nature of the misconduct alleged, and there was an attempt made to.
Yes, which is the passage that deals with my Lord's point?
Yes. So if one goes to paragraph 37, where there is the submission on behalf of the appellant that the refusal to grant relief was disproportionate to any damage, and that the judge's approach to the willfulness of the breach was wrong in principle. And then that was the submission. And paragraph 40, where we see Lady Justice Arden starts with the law, that relief can still be granted even though a breach is deliberate. Special circumstances do not have to be shown. And she cites a passage from Southern Depot and British Railways Board. There can be no doubt that the willfulness of the breach.
Shall we, any long passage, we'll just read to ourselves. How much do you want us to read?
But just if you can read the citation from Southern Depot, which
yes,
is there can be no
I've
doubt.
done that. Where now?
And down to the bottom of that 40. It refers to page 43.
Yes.
and then in paragraph 43 of this judgment, where there's a reference to the breach and the fact that the leasehold interest has a capital value. And there's then a citation from Magnick and Mahmood.
Do you want us to read that?
Yes, if you don't mind.
Yes.
And then paragraph 47.
Well, speaking for myself, I think I'd like to note the passage in 44. If the defendant's conduct amounted to a conscious disregard of the terms for relief which the court had imposed, then it would be much more difficult to argue refusal of further relief as wrong in principle, even though it would produce a windfall for the landlord.
Yes.
The balance to be struck will obviously depend on the relevant circumstances. So that may well be what you want.
Yes.
So, reference there to a balance.
I mean, they're not. There's actually no mention of clean hands here, is there?
Well, this is a case involving the fact that the I think this was a case.
There's certainly reference
the conduct of
47 to egregious conduct.
Yes, it was about the conduct of the, and there's reference also, I think, to. One moment. Yeah, I mean, there's reference to Shiloh, Spinners, and Harding. I mean, I interesting whether the use of the words "clean hands" appears or not in the.
I mean, I don't properly remember. But I know there's been long debates over how far you can get relief in respect of deliberate breaches. And I'm not sure that's necessarily the same question as whether you can come to equity with unclean hands and get relief.
Well, in my submission, the key passage is the one at paragraph 47, where the windfall point is about proportionality. The appellant's egregious conduct is not relevant to the question of the windfall, which was a freestanding consideration to be considered on its merit and then weighed against the appellant's egregious conduct. Once the value of the leasehold deed is an value which the respondent would obtain for forfeiture, it has to be thrown into the balance with all other circumstances. So,
Yeah. Well,
that
you say that's what you rely on.
yes.
We'll let you get back to your.
Yes. So
my Lord's question to you was: are you saying that you had to weigh the unclean hands against other matters? You say yes, and you rely on those passages, right? Where do we go from there?
yes. Where I go from there is to actually then look at what the judge did in this case, because
Yes.
we've already identified that when dealing with the strictly obiter consideration of the penalty issue, the judge did identify at paragraph 148 the very serious consequences and the windfall issue there. When he came to deal with it in relation to relief from forfeiture, what I criticise him for is that it's not at all clear from his judgment that the only context in which he quotes Freifeld and the passage, paragraph 47 of Lady Justice Arden, is not in the weighing of the factors, but is treating that passage as being relevant to the debarring of the claim for relief. So that I say is wrong in principle. So, so he uses that as the gateway, which I say is not what he should have done. He was not approaching it in the right manner, and therefore he hasn't properly balanced the issues and exercised his discretion, and he needs to do so. So this application for relief from forfeiture, if it's relevant, because of depending on the outcome of my first grounds of appeal, I say that there hasn't been a proper consideration by the court of the application because the judge got it wrong. He didn't ask himself the right question, and therefore he came to a conclusion that's not supportable, not sustainable. And what? But there are other features of this.
I see the time. You are going to leave yourself time to deal with the point that even if the judge did consider forfeiture in the alternative, I haven't misled myself about this, have I? And found that even if the defendant's conduct didn't disentitle them to seek relief, in any event, relief should not be granted.
Well, yes, I'll do that if I may. Again, fairly efficiently, if I may. First of all, it's difficult to follow the judge's reasoning in relation to this, and also his findings, because the judge appeared to treat the question of windfall as being something which didn't arise in this case, and it's difficult to follow what he says, leading to the conclusion at paragraph 177 that the appellants had not shown that OCM now will receive a substantial windfall from taking possession of the courage. The judge's conclusion there seems to be based upon proof, and it seems to relate to matters that are unconnected with this, which is the question of getting access and valuing, and the idea that in a case where there was nothing to indicate that there'd been any dramatic implosion in the values that were attributed to these vessels, and the competing desktop valuations between the parties suggested a span, albeit that they hadn't inspected. In my submission, the judge wasn't really open to the judge to suggest that the appellants fail because of absence of proof in relation to the windfall. It may be relevant to misconduct in terms of whereby the conduct courage had prevented the respondents from inspecting and obtaining their own evidence of that condition. But in my submission, he should not have simply taken out of the equation altogether the windfall benefits to the respondent. And we can see in my submission that for whatever reason he was taking a position here which we say is untenable in terms of the proper due exercise of a discretion. Because in relation to Amethyst, where the position was different, the judge, with respect to him, appears to acknowledge that there's a potential windfall, but doesn't actually deal with it, and fails to take the unconscionable and disproportionate benefit into account as part of the exercise of his discretion.
Well, he does take it into account. He finds there is one at the end of 178, but he doesn't regard that as decisive because of the other features which he goes on to consider. Well, I suppose, yes, sorry, I'm just reminding myself of exactly how he dealt with this. At 180, he says that if it had depended on the...
Yeah.
Sorry, let me just make sure I've understood that correctly.
So it comes back to the gateway point and to the point I've made previously. But what I'd say is that the judge hasn't properly conducted an exercise of discretion in relation to either of these two vessels, such as to make it safe to rely upon his conclusions and his judgment, that refused a significant equity that otherwise available to the appellants. And in our submission, this issue is fundamentally flawed, the way in which it's been dealt with by the judge. That he hasn't used the appropriate test, he hasn't taken into account the appropriate benefits and detriments, and he hasn't considered the corresponding unconscionable and disproportionate losses that would be suffered by the appellants. And therefore, this order refusing the application for relief should be set aside, and the matter, of our submission, should either be remitted or should be the subject of fresh exercise of discretion. I better just say this finally, because I don't want to lose this point. In case the other thing that clearly influenced the judge were matters which we say are extraneous to the questions relating to what was immediate and what was relevant to the relief from forfeiture. There may have been issues concerning things such as sanctions, practical matters like where the vessels were, things like that, but all of those matters can be dealt with and should be dealt with once the judge properly exercises discretion because many cases involving relief from forfeiture involve conditions. So many of these things would have been, if an exercise of discretion applying the appropriate tests had been used by the judge, then it doesn't follow that there was any impediment to granting relief from forfeiture, since issues such as conditions being applied to the grant would have
what sort of, I don't quite understand what specific point you're making. What sort of points do you say might, or you're not making any concession,
no.
Principle you'd like, unconditional relief from forfeiture, but what conditions do you mean?
Well, so the obviously typically there would be the payment of outstanding sums.
Yes, I see. Well, in that sense, relief from forfeiture obviously involves payment of the sums, all sums
the fact that it's slightly more cumbersome in this case because of sanctions and the need for license and where the money is coming from and so forth. Those are matters that could be worked through.
Yes, if by conditions all you meant was a condition that the sum be paid, and as you say, there might have to be some details because of the unusual circumstances here about methods of payment and so forth. But is that all you meant by conditions?
Well, I mean, there could be, if for example, the judge felt that there was a legitimate interest within the continuing relationship, if these go to grant relief from forfeiture, for there to be inspection, for example, by the owners of courage, then that could have been a condition, for example. The equity is very broad.
What were you actually asking for? Were you saying that effectively the termination of the charter party should be set aside so that the relationship would continue?
Yes.
Or were you saying that the charter party should be terminated but somebody should pay the other side some money? And if so, who pays what and
No, what was being sought was relief from forfeiture, which would mean restoring the parties into their relationship of owner and charterer.
So the order which the judge ought to have made.
Just one moment, 'cause I'm just finding out. Yes. So it's restoration of the charters or restitution or relief in respect of the payments made to the claimants.
Well, let's just examine that a bit. When you're ready.
Yes. Yes.
Restoration of the charter, so that means that the judge ought to order the owners to remain in a continuing contractual relationship with sanctioned charterers. Yes?
Yes.
Okay. And right, and the other one, restitution relief in respect of payments made to the claimants. So how does that work? The claimants get the vessels but have to pay back the charterer's contribution, or what?
Yes, I think the counterclaim, it was a formal counterclaim, and I'm reading from the counterclaim.
Give us the page number in the bundle.
Page 124, I think.
Yes, thank you.
The owners can't make payments to the charterers, can they, unless they're going to get themselves into trouble with the Americans?
Yes, unless it's the subject of license.
Well, they were never going to get a license to pay money
Pay
to
them.
an entity controlled by a designated person.
Yes, the certainly so long we're looking at it from the perspective of the application, and I don't know whether it was being suggested that Mr Mallah was taking any steps, or steps were being taken to sanitise the position, which might have again formed part.
Anyway, I understand now what you're saying. Relief from forfeiture ought to have meant in practice.
There was a range of possibilities in how this could have been dealt with if the judge had gone on to consider the matter.
Well, that range is specified in your four alternative, though, yes. I think, overlapping forms of relief in the amended counterclaim. And that was the position as put to the judge as well, was it?
I understand that to be the case. Yes.
Yes, I see. Well, I do now see the time. I think.
Yes.
Is there anything more you need to say?
I'll just take instructions. Well, those are my submissions on relief and forfeiture.
Thank you very much indeed. Mr Bright, your time is somewhat abridged, but I don't think in a way which should prejudice you, because the issues are quite tightly defined. If I can give you a steer, I think, of course, we would be happy to hear some summary submissions on the construction issue. But if you were to focus particularly on the relief from forfeiture issue, I think that would help us most.
I of course, will do what I'm told.
Well, no, that's not quite true. You can do what you like. But I'm just telling you what we think at the moment is most likely to help us.
Well, I only want to help the court. On that, I will deal with construction first, but I'll try to do so briefly. Before I forget, though, on the question just asked, given the four overlapping forms of relief, which are summarised in the judgment at paragraph 10, right at the end of that paragraph. There were, my Lord Justice Mayall's question was obviously right. It was impossible for us to do any of those things without a licence, and we weren't going to get a licence, as indeed the judge found. It has to be remembered that what was being said at the trial was that Mr Mallah was no longer the beneficial owner of these parties. That was the basis on which the counterclaim was brought and relief from forfeiture was advanced, seeking those particular conditions. And if that had been established before the judge, then that might have been a vaguely arguable case. But in the light of the judge's conclusion that in fact Mr Mallah was still the beneficial owner and that he'd been lied to about that in order to make the case for relief from forfeiture seem workable, the case on relief from forfeiture simply falls apart at that point. That's ultimately the problem.
Well, sorry, it might fall apart for clean hands reasons, but I don't think that's what you're meaning.
Well, let me show
just suppose that there wasn't any of this complicated background and we're dealing with some other event of default. And let us suppose that we weren't going down the route of restoring the relationship of the charters. Surely the what would then happen is that the vessels would become, or would remain, what they nominally were, belonging to the owners, who would in practice, since they're not in business, sell them. The value would be shared proportionate to the contribution, the net value, proportionate to the contributions that each had made to their purchase. That would be the practical form of relief on that basis. And if that were the case, I appreciate the money could not be paid over to any entity of Mr Mallah, but I would be surprised if there wasn't some way of placing it in escrow or in a bubble in some way, so that you didn't get the benefit of it, and the question of whether he was entitled to have it would be resolved in some other way.
Well, nobody else was asserting that they were entitled to have it. I mean, he was the only,
No,
he was the beneficial owner. That was the problem that the judge faced. And I said I'd go through construction first, but let me just see if I can knock relief from forfeiture on the head first.
Okay.
My learned friend is quite right. The judge did approach it in two stages, and I accept that he looked at conduct first, deliberately confining himself to highly relevant conduct, and concluding that that alone was sufficient, without more, to debar any application for relief from forfeiture. And my friend calls that the judge using it as a gateway, and I'm happy to adopt that terminology. Without troubling your lordships to look at the law, although we may have to, if it turns out that there is a glimmer of a possibility that the legal question might be determinative. What the judge then went on to do, however, was to say that he would then look at the question of relief from forfeiture, ignoring conduct, and he came to the conclusion that it would not and could not be granted because, essentially, of this problem. So, looking at the structure of the judgment again, we go to paragraph 165, where there's the preliminary point about conduct being assessed, and the judge sets out the particular conduct that he has in mind. And then at 166, I therefore, sorry, I'm going too fast. 166, I therefore conclude that's his conclusion, that he won't entertain the application. But I shall comment on it relatively briefly. He in fact comments on it all the way to paragraph 190. So he sets out the law, and my learned friend accepts that he sets out the law correctly in paragraph 166. He then comes to the pleaded grounds, and he sets them out fairly, including the good conduct in the past, that's at 167. Then 168, Mallah's name was wrongly included. Well, he can't take that into account. There are no events, there was no fault on the appellant's part. He deals with insurance, for example, in that regard. 170, he observes in passing that if there's a continuing event of default, it could be cured, but then he notes that, in fact, all the evidence suggested that it couldn't be cured, and that's the inference he comes to and the conclusion that he draws. 171, he refers to Mr Mallah supposedly having applied for his name to be removed, but there was no evidence about that, and your lordships, some months down the line, know that that hasn't happened. Then unconscionability, and this is the windfall point, and he deals with, I'm not going to read out loud, but your lordship will have seen at 176, he deals with windfall in relation to the courage, and the submissions that I made in response to Mr Dunning's. And at 177, he concludes that the defendants have not shown that there would be a windfall. And he does so because the state of the evidence is unsatisfactory, although there were obvious reasons for thinking that the value of the courage was very seriously impaired. All I would observe is that in this context, there must be some sort of burden on the person seeking to apply for relief from forfeiture to show that there is a windfall. And insofar as Mr Barclay says, well, there was no evidence, it must be remembered that at trial, his clients offered no evidence. Their decision. And I reminded myself just a few moments ago of the grounds of appeal set out in the bundle, which I'm not going to take your wishes to. I'm just going to say it's not apparent to me as I read them before and as I read them now, that there was intended to be any challenge to the factual finding in paragraph 177 of the judgment that there's no substantial windfall in relation to the courage. And I would have expected that to be advertised in the grounds of appeal if there was in fact intended to be an attack on the finding of fact, and that would be a bold submission to make in the context of an application for permission to appeal and an appeal when you have no facts. That's the courage. Then in relation to the amethyst, he notes with one major qualification, the defendants have a stronger argument in relation to the amethyst, by which he means a stronger argument that there is in fact a windfall, or would be a windfall. And then the qualification is set out in 179. 180 if my decision on the application for relief from forfeiture, meaning assuming they've got through the gateway, because this is the way that he describes his approach. If you scroll back to 166, where he is now pretending that he does entertain the application as opposed to debarring it because of conduct. If, therefore, it's depended on windfall for OCM Karma, which means the amethyst, I would have invited further submissions. But I refused the application for relief in any event. He doesn't merely mean because they don't get through the gateway. He means because of what he's going to go on to say in the next paragraphs. And this is where he deals with the contention that the sanctions regime, the appellants contended, did not prevent the charter parties from being performed. And here you see, in support of this, they relied on their case that Mr Mallah had severed his connections. And this is the case that, as you know, he's already rejected and he's going on to confirm now again. I don't accept that. Therefore, that argument fails. And then he says at 182, 3 questions arise. Assuming no license, could the charter's parties be lawfully performed? Could the claimants make restitutionary payments to the defendants? If so, and assuming no license is granted by OFAC, would the claimants be exposed to risk under the sanction regime? And then what are the prospects of OFAC granting a license? I won't weary you because your lordships can read this for yourselves, but he's going to conclude that the answers to those questions are negative. And he ends up saying at 189, little prospect of licenses. And at 190, I consider that these reasons are in themselves sufficient to show that it would not be appropriate to grant relief from forfeiture. So he rejects the application to relief from forfeiture on 3 entirely separate bases. 1, because they don't get through the gateway because of their conduct. 2, in relation to courage, because they haven't shown a windfall. And 3, in relation to both ships, because it is simply not possible or sensible or just for the court to do what they ask, because it would be putting my clients in peril of being seen to breach US sanctions, getting into trouble with the US authorities, themselves being blocked, having their principals, by which I mean the individuals in the United States or who are US citizens who have to do things on their behalf, being at risk of being put into prison, and the companies behind them in the United States being subject to enormous fines, because these are all the sanctions that the US authorities enjoy imposing, in particular the enormous fines.
Have I correctly understood in relation to the amethyst that his finding at 178 is that, subject to the point he's about to make in 179, there probably is a significant windfall,
yes.
But the effect of the point in 179 is that there is at least a possibility that the amethyst is in effect encumbered with a claim for $12.9 million, and it is that on which he would have wanted to have further submissions if that was going to be a decisive point.
That is my reading of the judgment, yes, my lord. But he ends up saying, but I don't need to, because even if there were a windfall, and even if they'd got through the gateway, I wouldn't be going there.
Yeah, no, I follow that. But that's
but yes,
that's why he says what he says about the value of the
that's right. But if my learned friends were to succeed on this point, he can't possibly succeed in relation to the courage. But if he were to succeed at all, then the result would be a remission in relation to the amethyst for that further evidence. So if this is the answer your lordship is asking, this isn't a case, I suspect, where the court could exercise the discretion for itself because the facts are missing and one would have to go back and find them out.
Oh, I haven't got to thinking about that yet.
Well, I'm not trying to encourage your lordship, obviously, to head in that direction. But that's the reason, fundamentally, why relief from forfeiture is utterly hopeless that's even accepting that my friend is right on the law in principle. Whereas, without taking your lordships back to the authorities, unless it's helpful to do so, I would echo the observation from my Lord or Justice Newey that Highlands is suggesting that where you have unclean hands, meaning that, for example, you breach a court order, as happened here, let's be frank, or are dishonest in the evidence that you produce to the court in the course of the application itself, then you are disqualified. That's different from a deliberate breach, which was the kind of conduct that was being looked at in the Freifeld case. Those two things are different in kind. Anyway, that's the nub of what I would say, but I suspect it's more efficient for your lordships to read the judgments for yourselves. That's all I have to say on relief from forfeiture. Potentially, I would have more to say in relation to construction, but not if the court thinks it's not going to assist.
Well, that is economical, Mr. Bright. Well, I think the court feels it understands the issues, and if you're inviting us to say that we positively want you to hear any more from you, I think the answer is no. And I imagine, Mr. Barclay, that in those circumstances any reply would be very short.
Yes, just a short reply, if I may, on the question of relief from forfeiture. First of all, the suggestion that the dichotomy between unclean hands and in terms of the conduct relating to the equities and difference between that and the presentation of the case or breach of the court order as being somehow different, and there not being a necessity to carry out a balancing exercise to have regard to the equities and the detriments and benefits overall, my submission is a false dichotomy.
Sorry, can you speak up a little?
Yes, a false dichotomy to suggest that the nature of the conduct being relating to, for example, the manner of the presentation of the case, as opposed to deliberate breach. If deliberate breach, which gives rise to the forfeiture, does not preclude the consideration of the balancing exercise, then we say that that would apply for Shiara in the connection with things such as a breach of a court order or the judge's rejection of facts and the manner issues concerning the conduct in the course of the trial. Ultimately, it's going to require the court to carry out that balancing exercise. The second point I make is that the judge didn't make a finding, which is the subject of an appeal, that there was no substantial windfall. He didn't make that finding. The finding that he makes at paragraph 177 of his judgment is that he concludes that the defendants have not shown that the Nile will receive a substantial windfall from taking possession and selling her. He dealt with it on the basis that he was pushing the burden of proof onto the appellants.
The burden of proof is clearly on the party seeking relief from forfeiture. Your point is more a point about evidence. You say that burden is, in practice, shifted by the desktop valuation.
Indeed, and also by the judge, by everything the judge knew, including the other findings that he made in relation to the penal nature of the provisions. Which is why, in my submission, he's expressed it not by making a finding that the vessel has no value, but by saying that the defendants haven't shown that, and that, in my submission, reveals the position that the judge has used this as a basis on which not to grant relief, and he hasn't treated the question of windfall seriously for the purposes of the exercise. And the same can be said, well, even more so in the case of the amethyst, because although the judge acknowledges that the case is strong in the case of the amethyst, in my submission, what he has done is not had sufficient material upon which to make any finding in relation to that, which is why he deals with it in paragraph 108 of his judgment in the way that he does. He couches it on the terms that he is dismissing the application on the gateway issue. Otherwise, he would have invited further submissions.
What Mr. Bright submits, and certainly I hadn't fully understood the structure, is that, and now it seems obviously right to me, subject to you persuading otherwise, that the reason why he felt it would be, ignoring the gateway point,
yes,
the other reason why he felt it was unnecessary to call for further evidence about the value of amethyst, which would also include the question of the 12 million claim, is the points which he considers in the final paragraphs about it being impossible to achieve any, to give effect to any relief from forfeiture, because all the ways it could be done would involve breaches of the sanctions.
Well,
and that's the reason why he didn't find it necessary, quite apart from any unclean hands point, to go down the route of attempting to obtain further evidence about the value of amethyst.
yes,
That is structurally right, isn't it? That's how the judge's reasoning went.
yeah, but the question is whether that's a proper consideration, because we know that the designation of Mr. Mallah is what brings all this about. Until then, the charter parties being performed in a regular fashion. And at the heart of all this was the contention that that because of his designation, which precipitated all of this, that prompted the termination, that prompted their attempt to repossess the vessels, so the heart of all this is the question whether, in the exercise of discretion, that breaches or forfeiture that has occurred in those specific circumstances should, in those circumstances, strip the appellants of all the benefits of the contributions made till then, and transfer all the value to the respondents. That consideration is one which has little to do with Mr. Mallah's designation. It is merely, a bit punitive. It's punitive for the appellants to be stripped of all the benefits of their contributions and to have all the value transferred to the respondents.
Can I just clarify something? You've made submissions, I think, at an earlier point that, if necessary, because Mr. Mallah was a designated person and
Yes.
there would be difficulties about payment, something could have been worked out.
Yes.
For example, payment into escrow.
Yes.
Or whatever. But as I understand it, no case to that effect was put to the judge. Your case before the judge was not that you were sanctioned but something could be worked out, but that you were not sanctioned because Mr. Mallah had divested himself, and that was the only case you made. Is that correct?
I understand that to be the position. Yes. Other than there was a suggestion of a license, but the judge found there was no reasonable prospect of him doing that. But I think otherwise,
And really, no doubt for that reason, I'm just looking at grounds of appeal. It's not one of the grounds of appeal that the judge is wrong to reach the conclusions and take them into account that he did at paragraph 181 following.
yes. I mean the judge made significant findings about Mr. Mallah's conduct and about the fact that Mr. Mallah was still controlling the appellants. What I've raises a question on the appeal is whether or not that's a sufficient reason to decline the exercise of the jurisdiction to grant relief, and even taking into account all the matters, including the fact that here we are in an English court applying English law in relation to the functions of the United States authority in connection with the sanctions regime. If the court was satisfied that that the effect of the exercise of contractual remedies, and forfeiture, meant that the appellants would be stripped of all the benefits of their contributions, would create a situation which was prima facie unconscionable and unfair, and transfer all the values to the respondent. In our submission, the judge could have gone beyond, and should have gone beyond, his disquiets concerning Mr Mallah's presentation of his case, or the presentation by the appellants of the case, which the judge found to be deceptive. And that goes back to the point that I make, that the manner in which the appellants conducted themselves at the trial was not a matter that went directly necessary to the exercise of the discretion in relation to the grant of relief from forfeiture, and in relation to unclean hands, it was only a factor to be taken into account.
Thank you very much.
Well, I'm sorry, there was one other thing, but not a submission as such. Only, I hope gently, to remind the court that the trial of this matter was expedited, which is why we had, I have to say, the pleasure of having
The trial, you mean the appeal? Yes.
Not that I complain about the opportunity to renew acquaintance with Sir Andrew Smith, which was, as I say, nothing but a pleasure. And this appeal also expedited.
Oh, sorry. Yes, right. So, what point you be frank? What you're saying? You want to know our decision and judgment as soon as possible?
Yes, because if we win, but no doubt the appellants, if they win, would wish courts in other countries to be advised of the outcome and to see the reasons. Mm-hmm. But I know your lordships can only do what they can do.
Well, we will just rise for a few minutes in any event.
So we can still be on YouTube. Yeah, we are. You're watching it? No. It would be something very postmodern about very millennial. Watching yourself in the room. Exactly. Yeah. Let's put my tea all down myself, so that'll be in the recording somewhere.
No one on our team even mentioned the t-shirt. So.
We were expecting the peel.
Yeah, obviously it's on me for not getting that t-shirt ready.
More than one t-shirt per case.
Oh.
We'll be in our costumes.
I arrived a couple days ago at my desk and there was like a little gorilla holding a handgun on my table. And my kid got on a little figurine for me.
It's the official DC.
Is everyone here?
Well, we rose simply to see what comfort we could give you about timing. We will be reserving our decision. I'm afraid, realistically, given the other commitments of the court, you will not get a decision this term, which effectively means next week. But in view of the expedition, the court will do its best and is reasonably confident, without any guarantees, that it can get you a decision at some point in the vacation.
Well, that's very kind.
May not be the first half of the vacation, but we're aware of the urgency, and that sort of time frame, I hope, will not create any insuperable problems.
Thank you very much.
Grateful.
We will, of course, the usual procedure will be followed. That means that counsel will receive draft judgments for the purpose of drawing to our attention any typographical or other minor factual errors, and more importantly, of agreeing the form of any consequential order and providing brief written submissions on any points on which they can't agree. You won't need, I think, to be reminded of the recent decision of this court in the Counsel General for Wales case about the importance of observing the embargo and the limited purposes for which the judgment will be circulated, and that has implications for who may see it. But you should certainly remind yourselves of the guidance given in that case. A related point, we're about to introduce a procedure, but I don't think it will have been implemented in the case of this appeal, whereby counsel are asked to supply individual email addresses for counsel and individual solicitors, those with immediate conduct of the case, to whom it should be sent in draft. And that may be particularly important in the vacation because people may not be immediately available. You're entitled also to give the name of a backup person. But what we don't want is for, as tended to happen when people were less concerned about this, for some sort of general clerks at or info at email address, which means many people might see it. We want a targeted list of individuals who will cover at least most of those who need to get it. Or at least one person on each side needs to get it in the vacation so as to alert the others. These days, people are never very difficult to find. So, can I ask you, therefore, to supply such a list, one from each side, in the next 24 hours, so that we know who, when we're ready to circulate the judgments, they should go to. They won't go to anyone else. So, thank you.
Grateful. Thank you.